Thank you, Mikhail. The second question, which we plan to include in our agenda, was the international taxation and international agreements of licensee and licensor, franchisee and franchisor, which are located in the different countries. Generally, Mikhail already said that it's very important to keep in mind who is the ultimate payee of royalties of any other payments under such agreements, and it's very important to know in which country such a licensor or franchisor is located. It's a matter of the governing law of contracts, of the agreements, and by the Kazakhstani legislation it is possible to establish any law on the choice of the parties, of the agreement between the parties. It can be a law of any other countries and not only Kazakhstan, with the only exception that all registration things or some other imperative norms will be covered by the Kazakhstani legislation, including the laws related to taxes. Very often in our practice, in the cases of franchise agreements, we meet such situation when a master franchise agreement is concluded with one of the licensees or franchisees, and such an agreement is covered in several countries. But then only the Kazakhstani license agreement or franchise agreement will matter for us. Before registration, the license agreement, or rather here it will be already a sub-license agreement with the Kazakhstani entrepreneur. The master agreement will have to be also registered in Kazakhstan, and then only after it, sub-license or maybe sub-license agreements will be registered here too. Very often such master agreements do not comply with the Kazakhstani legislation. It's very important to prepare at least a license agreement with some references to the master franchise agreement in full compliance with the Kazakhstani legislations, or prepare and register supplement agreements to the master agreements, which will relate only to Kazakhstan and not to the other countries as well. On the place of location of the franchisor or licensor will certainly depend the royalty, the tax rate, and here I would rather give the word to Mikhail, because my very general knowledge in this field are not sufficient to give you more details or sufficient correctness of these responses.
Yuri, thanks a lot. I can just maybe short repeat. I mean, it's really important if you have a kind of master agreement that you divide or clear, stipulate in the agreement what we're talking about, in order not to mix up with some management, with some advertising, etc. That's from this point very important. Why it's important also from the point of view of the domestic, means Kazakhstani code, inter alia. Since January 2023, there have been some changes in the legislation, and the changes stipulating that the taxpayer, I mean the companies who are using some patents or using the trademarks are now limited. Are limited and have to pay in fact more taxes. What is about the limitation? The limitation is in respect of some franchising, in respect of marketing and advertising, but also in respect of royalties, limited to 3% of the total taxable income. For companies who are dealing with some software, for example, I would say it's a really headache, because the amount of royalties exceeded the 3%. It's maybe 60%, it may be 80%. In pharmaceutical business, it may be also more than 100%. Depends on the goods. for which the rights, IP rights are granted. And how we behave here with that, I mean, we see on the one hand that the taxpayer has to plan it beforehand to adapt, maybe. And on the other hand, we see that such new regulations may be also violating the double treaties inter alia with Germany, because, for example, the Article 24, Para 4, it's clearly stipulated that it's a violation if some Kazakhstani companies with German shareholders are treated different than Germany will treat the German GmbH with Kazakhstani shareholders. We see here a potential violation. We know there's a lot of discussions about, and to be honest, it's not fair, because in fact it increases the taxation rate maybe twice, in fact, what we see. On the other hand, beside, let's say, this problematic issues, we see, of course, other related rules in the Kazakhstani code, like the rule of Article 244, where it's clearly stipulated that before some goods under the brand are brought to Kazakhstan, all these expenses are in fact deductible. I mean, it makes also sense from the economical point of view that the introduction of a new product, I don't know what, for construction or even for the daily use, the expenses are rising before the good is on the market. And it's important to know about that, and we would be happy to support your or our common clients together in this respect as well. Pause.